What is a problem, though, already is the law in Scotland about what evidence you can bring forward in a sexual offence case. And this law is specific to Scotland. Just listen to this. In the trial of a person charged with an offence, the court shall not admit or allow questioning designed to elicit evidence which shows or tends to show that the complainer is not of good character. Okay? So the fact that the accuser has made three previous false allegations, for example, that can't be brought up in court. You can't bring up if the accuser has at any time engaged in sexual behaviour not forming part of the subject matter of the charge. So if they claim they were raped on Friday night, the fact they had sex with the man again on Saturday morning, consensual, you can't bring that into it. That can't even be mentioned in the court. Okay? Or the next rule, has at any time other than shortly before, at the same time or shortly after the acts which form part of the subject matter of the charge, engaged in such behaviour, not been sexual behaviour, as might found the inference that the complainer is likely to have consented to those acts. Okay, so information that would lead you to think that the complainer had actually consented to them is not allowed in court unless it was in a very tight time frame. So any sort of information or messages before or after, not admissible in court, even though they're obviously highly relevant. Not conclusive, but relevant. You're not allowed to bring them in. Now, how about this one? You can't bring in any subject matter that might found the inference that the complainer is not a credible or reliable witness. Now, a reliable witness is one who can actually remember what happened. A credible witness is one who tells the truth. In other words, if you've got evidence that shows that the complainer actually can't remember what happened or actually is a liar, you can't bring that before the jury, before the court. That's not allowed. Now, all those rules there, you can apply to the judge specifically for an exception to them with a certain piece of information, but you get the drift. The idea is that you're supposed to think generally you can't. It's only in exceptional circumstances that you're allowed to point out that actually the person making the accusation is a compulsive liar. But generally the judge will say, no, you can't bring that into the case. Again, this is a quote from a lawyer who deals with this area. It says, these regulations are now so restrictive that many feel that the pendulum has swung too far away from the accused and towards the prosecution. Yeah, it certainly seems that way to me as well. Because the objective is to get more men convicted. The objective is not to come to the right conclusions so that the men who deserve punishment get convicted and punished, and the men who don't deserve it don't get convicted. No, that's not what they want. They just want more men convicted. Innocent or guilty, not so bothered about that. We just want more men convicted.